Hello and welcome back to my channel. I hope you are all doing well and welcome to today's video. Today is Monday and we are speaking all things law. Okay, so this week we are speaking about contracts. When are you actually obligated to Now remember guys, none of my videos are actually legal advice. If you are looking for legal advice, please go and contact a qualified legal provider and somebody who is actually an admitted attorney or an advocate or somebody who is a legal advisor and in their capacity as legal advisor. Right now, yes, I'm a legal advisor, but I'm not in my capacity as legal advisor. I'm just giving you information on what to look out for, and then you go further into seeking that legal advice and legal information wherever that you are. Okay, let's get into this video. Okay, first of all, don't forget to like, comment, and subscribe to this video, and let's see more videos of me speaking about law. This is weird. What is law of contracts? Law of contracts is actually forms part of law of obligations. So in turn, it is actually a law of property, but and also under a broad category of private law. What is law of obligations? It means that it is a legal relationship consisting of a right to performance coupled with a corresponding duty to render the performance. One cannot be legally bound to perform something when the other person has, in order for it to be an obligation, one needs to be bound to perform a certain something and the other has a duty to render the performance. That's what law of obligations mean. But then that's not where law of contract end. It goes on to, it has to be an agreement. Minds have to actually agree. Section 1 of the Consumer Protection Act 68 of 2008 defines agreement as an agreement or an understanding between two or more parties that purports to establish a relationship in law between or amongst them. The agreement has to be in law. It has to be between more than one person, and so you see where it's going. You can't just be in an agreement with yourself. You can have it, but it's not a contract. Okay. And if you want to research more of that, you're free to go and read on it. And then the next thing about contracts, in order for one to have a contract, is it has to be a consensus. What is a consensus? A consensus, there has to be a meeting of minds. You could have an agreement, like say for example, Sasa Sizoya eThekwini. That's our agreement. But then siyokwenza eThekwini, and what are the things that we're going to look for in Durban? There has to be a meeting of minds and in terms of time. So consensus relates to an intended obligation. What is that particular obligation that who must perform and who must do what? Who's supposed to give you something? Say, for example, it's an agreement of a sale of a car. Who's supposed to deliver the car and who's supposed to pay for the car? So there has to be a consensus in relation to the intended obligation. And with the next thing about consensus, you have to actually be wanting to be legally bound. That's why when you, let's say you are buying a phone in online or telephonically, the next thing that they're going to ask you is, are you actually, though they read that contract very fast and that legal part very fast, don't know why, always ask them to slow down, repeat stuff, always do that because you might bind yourself to the craziest stuff. So you have to have an intention to actually be legally bound. Should this contract hit the fan or whatever, I actually intended to be bound by this legally. I intended that the contract, should anything happen, I would say, yes, this is what I wanted, and I would like the hand of the law to actually take its course, whatever the case might be. And also the third thing about consensus consensus is that the parties must be aware of their contract. Could be that, for example, I'll go back to cell phones. They sell you a phone and you agree to buying a phone. Then they add a life policy or a life cover. You didn't agree to that, so that contract does not meet the requirements of consensus. Le party yoguti usune life cover. Yes, you agreed to a contract le yokuthenga phone, but you did not agree to buying the additional stuff. So moving right along in terms of foundations of contract, how do you actually cancel a contract when there is misrepresentation? They sold you something and it's not what you wanted to buy. You have a justifiable reason to actually cancel that contract, to actually cancel that your side of the contract. Maybe you have a duty to pay, they have a duty to provide you with whatever that you are buying. All right. So what are the other foundations of law of contracts? Capacity. Who has the legal capacity in contracts? Capacity is very important when you are dealing with contracts. Not just contracts, but in many things in South Africa, when you are dealing with litigation, who has the locus standi, all of that. Law students and CAs need to be very much aware of that. In terms of minors, most of the time, if not all the time, parental consent is required. If you get into a contract with a minor and they didn't get the necessary consent, that contract is actually void unless the minor is voidable, unless the minor, when they become a major. So say, for example, get into a contract with a minor who's 17, turning 18 next month. Because when I was in varsity in February, I was 17, but May I was 19. So if I took a contract in, say, April, and then when I turned 18 in May, I continue with the contract, and I go there and say, no, I want this contract to continue. I'm now a major, and at that point, I have now made the contract valid. If I decide that at the time that I turn 18, no, actually, I didn't want this contract, it was under misrepresentation or whatever, I could cancel the contract, because the contract is actually voidable because you entered into a contract with a minor without the necessary consent. So be very mindful of selling stuff to minors, and especially minors who are not emancipated, and be very mindful of that, especially when drafting contracts as somebody who's actually been asked to draft a contract for a particular client. You have to be mindful of, is there capacity? And again, in terms of minors, the parent can actually consent to the contract later if the minor entered into a contract without their consent, and then the parent says, okay, it's actually a good contract, I don't mind it continuing. But if parents decide that it's not, and you actually don't really have much legal recourse to that. The next person another thing about minors is that a minor under the age of 15 cannot be employed in terms of section, can't remember section bani, but in terms of the Basic Conditions of Employment Act, a person who's younger than 15 cannot be employed. And if you employ such a person, again, people who are drafting contracts, if the persons, you look at their ID and their ID number is under the age of 18, that could actually, according to the Basic Conditions of Employment Act, that could actually mean that that person is criminally liable, is committing a criminal offense. So be mindful of that. And then people that also lack legal capacity to contract, it's people under administration in terms of Section 89 of the National Credit Act. Persons who files an application for debt review, and unless that person is rejected and the application does not get approved, that person has no legal capacity unless they get the consent of court or whoever. And then married persons, and then if you are contracting with a business under business rescue cannot get into new contracts. Be mindful of that, read more on that. And then persons married in community of property. Persons that are married in community of property need the consent of their spouse. So those persons have a limited legal capacity. It could be written consent if it's sale of land. It could be verbal consent if it's any other consent. So any other sale, but yes, you have limited capacity if you are married in community of property. I always say this: whatever you do, however in love you are, don't get married in community of property. In terms of contracts, especially in businesses, one could be an agent and starting a contract with getting into a contract with another business. You have to be very mindful. Does that person have the actual legal authority to sign the said contract? Say, for example, you are a CA and you decide, I'm going to impress my boss and sign a contract and get a client, whatever it is. And it turns out your principal does not even want that contract. And that contract could actually be void because you don't have the necessary capacity. Look at the case of Makate and Vodacom. That's one important case in terms of principal and agent relationship. If you want to learn a lot about that, read that case. It's very important in terms of that and who has the necessary authority. And then certainty. All parties must actually be in agreement about all the terms in the contract. Could agree that we're going to Durban, but maybe I think we're leaving on Wednesday and then the other things we're leaving today. So we're not really in agreement with the terms of that contract. So you should be mindful that parties actually understand the contract that they are getting into. And another thing that need to be considerate of is legality. Is the contract actually legal in South Africa? There are many criminal offenses in South Africa that are not criminal in other countries. And if it happens that you get into a contract and it's actually not even, you get into a contract and it turns out that here, we don't even consider that as legal. And you could get into jail for that, and the contract could actually be voidable. Or it's not void, but it could be voidable. Void and voidable. Research on what's the difference between that. Read further if you want to understand what's void. Void means the thing is invalid. Voidable means the thing could be invalid. Read more on it. Okay. An important thing to note about contracts: the principle of freedom to contract. Why is it important and why do I have to actually mention it? So the first principle that you need to be mindful of when you're looking at freedom to contract, it's the Pacta Sanct Servanda, the agreement to must be kept. That's one important principle about contracts. That's why that's the important part of law of obligations. But with our country being a constitutional democracy, we have the principles of Ubuntu and public policy. So when making a contract and when creating a contract, although there is this important principle of Pacta Sunt Servanda, you have to actually be mindful of Uguti. Does this actually not infringe? Are these factors that I'm putting into this contract not against public policy, and are they not affecting one's right of dignity? And one important case to remember on this, it's the Barkhuizen case, Barkhuizen versus Napier case. I'll link it below. Very important case, although the contract was kept running because of some certain factors that were missing. What some of the important factors were later discussed in Botha and Another versus Reach. I'll also link the case here. And one of the important things that you need to note about contracts is that, yes, contracts are freely entered into and must be honored, but the importance of contracts cannot be privileged over constitutional rights and values. So if you're creating a contract and you probably maybe are infringing on the right of right of protection against unfair labor practices, if you create that contract should be void because you are now infringing on the constitutional right of this person and public policy and Ubuntu, and you are violating constitutional rights and the values of Ubuntu. This does not automatically mean that the contract will be cancelled or will be void. What the court looks at in that particular case, so it's a subjective view of every case, each case is different. They look at whether the thing was actually unfair, that principle that you actually put, or that term that is in that contract, was it unfair, was it unreasonable and unjust, and it is contrary to public policy, that the court may refuse to enforce that contract or that term that's in the contract. So yeah, when we are making contracts, especially, I think this is very important for us who are starting into drafting and drafting contracts and understanding. You need to remember and be mindful of our constitution and what it requires of us and what the courts actually look into. The contract might not all be void, but maybe the terms might be voidable, and then maybe that's an important factor of the contract. So whatever contract that you are drafting for your client, please be mindful of these values, because that contract could actually be impeachable. So when drafting a contract, I think the first thing that you need to do is take incwadi yakho and read on law of contracts. Read the book, read the cases, read what the courts are actually saying about contracts at that particular time. Okay, final reminder, this is not legal advice. If you're looking for legal advice, please find somebody who is certified to actually give you that legal advice. All right, I'll see you on my next video, and yeah, don't forget to like, comment, and subscribe to this video, and to this channel. All right, I'll see you guys.